the next case to come before the court, it was for Elyria Company LLC versus Brexton Construction Company LLC et al. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, introduce yourselves, keep your voices up. You should not use the names of children or minors or victims, should that be relevant, which I don't think is relevant in this argument. But we have read your briefs and we're ready to proceed when you are, and I would just tell the appellee cross-appellant that you will have to argue your entire argument during your 15 minutes. And I would ask the appellant if you would like to reserve time.
Yes, Your Honor, I'd like to reserve 5 minutes, please.
Very well.
Your Honor, would I be able to reserve, because we have a cross appeal?
No. You have to do it all within your 15 minutes. Okay. Thank you. You may proceed when you're ready.
Thank you, Your Honor. May it please the court, I'm Christine Garitano, and along with John Murphy and the law firm of Harps Becker, we are here on behalf of the plaintiff appellant for Elyria Company LLC. For Elyria asks this court to reverse the judgment of the trial court that granted summary judgment in favor of the appellee Brexton Construction on its counterclaim for unjust enrichment, and also in favor of Brexton and against For Elyria on For Elyria's affirmative claims of breach of contract, slander of title, and fraud. And I'll just start by saying the trial court's decision, should it be affirmed, represents a significant departure from legal precedent, contract law, and most importantly, the construction industry as a whole, as we know it in Ohio, and quite frankly, nationwide. For Elyria has 4 assignments of error. They all stem from essentially the single issue that the trial court decided here incorrectly, which is, was the Petco tenant improvement work within the scope of the construction management at-risk agreement that was entered into between the parties? And in order to reach that interpretation, the court not only ignored all of the terms of that contract, but ignored the entire context in which that contract was made, again, in the construction industry. So what's important to understand at the outset is, appellee's position is, these Petco tenant improvements were outside of the scope of the contract because the plans had not been finalized at the time of contract. In all construction projects, big or small, there is work that happens during the project that is outside of the scope of the contract when those parties sign that contract. And the way the construction industry deals with that is by including contractual provision called a change order provision. And Ohio law, the Supreme Court, has upheld parties following those provisions very strictly. Foster, Wheeler, Duke, and Myers. In those cases, the courts have said, when work is outside of the scope of the original contract, it is incumbent upon the contractor to submit and obtain a change order for that work. That didn't happen here. It didn't happen here for a number of reasons. But what the court did is ignore that entirely. Read the contract.
Can you give me some of the reasons why it didn't happen? That can be gleaned from the record, obviously, you know.
Sure. If you're asking why did the appellee not submit and obtain a change order, I think the answer is that they mismanaged the project. They misbid their work and they mismanaged it throughout. It came to the attention at some point.
I mean, is that in the record? Is there?
Yes, Your Honor.
Okay, thank you.
Yes, there is testimony in the record that the CFO of Brexton came to realize at some point that there were significant cost overruns. At that point, it was essentially too late by the terms of the contract to get that change order. In fact, they internally circulated a change order, which means they understood they needed a change order for that. Change order provision requires the contractor within 14 days of having knowledge that the work has changed in scope, to come to the owner and negotiate the terms of that change order. They didn't do that.
Is it disputed that whether they did it or not? Is it a disputed fact?
It is undisputed that Brexton did not submit a change order to Elyria. They internally circulated one, those facts are in the record, but they did not ultimately submit that to the owner.
Thank you.
But isn't it a disputed fact then that was a change versus a separate contract?
I think the issue is, was Brexton obligated to perform the Petco tenant improvement work under the terms of their agreement? I think the answer to that question is unequivocally yes. There are references throughout the contract to the completion of the Petco tenant improvement work. There is a date in the contract by which that work must be complete. The issue is, did Brexton have enough information when they submitted their guaranteed maximum price as part of that contract? Because they had the prototype plans. Did they have enough information at that time? Maybe they did, maybe they didn't. I'll submit to you that should we be able to submit the facts on that, the prototype plans gave them everything they needed to properly price that one. The final site plans didn't change much of anything as far as the pricing would go. They missed their bid. They mismanaged the project for whatever reason. But there are several references to the fact that Petco tenant improvement work was going to happen. And we know it. We know that because Brexton did it.
So if we find that the court erred in denying or in granting the summary judgment motion for the appellee on that issue, and we find that there's issues of material fact on that issue, does that domino the whole ruling? Is this the main issue here, or whether there's issue of material fact on this issue?
The prime issue is, does the contract unambiguously exclude the Petco tenant improvement work?
Right, and
Our answer
you're saying it does, and they're saying it doesn't. Right?
We're saying it includes the Petco tenant improvement work. There then becomes an issue of fact, I believe, potentially as to whether or not the scope of work that they performed was different or more than what they bid as far as their initial GMP. Yes, that is a potential issue of fact.
And then would that leave all the claims going to a jury trial? If the court found that there's an issue of material fact on those issues?
Yes, sir. And so I'll just turn to some of the specific language in the contract that the trial court very clearly ignored here. The trial court relied on a single sentence in a note by the architect in the final site plans that were incorporated into this contract. But when it did that, it even ignored the preceding sentence of that note. So the note that the trial court relies on starts by saying, the project consists of the shell building and landlord's TI work. TI meaning tenant improvement, everybody understands that. The next sentence says tenant's interior work to be submitted under separate contract. Now, that second sentence is what the trial court is relying on here to say that the contract did not include that. But it entirely ignores the preceding sentence, which says that the project does in fact include that. So, what I would say is, maybe that's a conflict, maybe that's a contradiction. At best, it makes it ambiguous, at which point the trial court was obligated to look outside of the language of the contract to the extrinsic evidence. And when you look at the extrinsic evidence, every single bit of that extrinsic evidence establishes the intent of the parties, specifically Brexton, that the Petco tenant improvement work was to be included. That extrinsic evidence, again, is the fact that they internally circulated a change order. They did the work. It strains reason to suggest that a contractor would perform $500,000 of work with no contractual obligation to be paid for that. That is an unreasonable thing to do. We also know that Brexton intended to include it because its subcontractors were issued change orders to their contract to perform that scope of work. And that's important because the Brexton subcontracts include a term that, one, incorporates the terms of Elyria's contract with Brexton and condition payment to its subcontractors on whether or not the owner pays Brexton under the terms of its contract. So every bit of the extrinsic evidence here, even if we say that the contract was ambiguous, suggests the intent that the Petco tenant improvement work was included in this contract.
Was there a claim for foreclosure here?
Yes, I believe what ultimately happened was, because Brexton realized that it missed the change order provision, it failed to comply with that, and Ohio law is very clear that a party waives its right to get paid when it does not comply with the change order provision. It ultimately filed a lien, and there was some litigation over that lien, and that lien is part of Elyria's slander of title claim.
And has the property been foreclosed upon?
No, Your Honor, no, it has not.
And counsel, I just want to let you know, you've moved into your rebuttal time. You're about at 4 minutes and 30 seconds.
Okay, Your Honor, if you don't have any questions now, I'll reserve for the next portion. Thank you.
You may proceed.
Thank you, Your Honor. May it please the court. My name is Joe Gunther. I'm an attorney at Brexton and Hollister, and we represent the Elyria and cross appellants, Brexton Construction LLC, Mary Beatty, and Tim Galvin. This case has kind of a long and tortured history. This is the second time it's been up on appeal, so there's been extensive briefing. But I just want to highlight a few points, including a few of the points that counsel for Elyria mentioned. Number one, counsel for Elyria argued that what the trial court did was contrary to well-settled Ohio law. And counsel didn't use this term this morning, but it is in their briefing that affirming the trial court decision would fundamentally alter contract and construction law in Ohio and more or less open the floodgates. That is not true. That is hyperbolic, and Elyria relies heavily on the two Supreme Court cases, Foster Wheeler and Dugan and Myers. First of all, those cases are factually distinguishable, and I'll get to that in a second. But more importantly, those courts also state, and it is still well-settled law in Ohio, that courts are required to look at the four corners of the contract, interpret the terms of the contract, and apply the plain meaning of the contract. One of the issues in Foster Wheeler and Dugan and Myers was that there was a provision in the contract that said if the contractor failed to submit a change order for extra work, it will have waived any right to additional compensation. There is no such waiver language in this contract.
So so every person having a construction project would have to put that additional language in to make sure everything was in writing?
Yes, Your
More
Honor.
than one project?
Yes, Your Honor. If an owner is concerned about additional claims for additional compensation without a change order, that language, the waiver language, needs to be in the contract. It's
You
not-
can't just say it has to be in writing if there's going to be a change to a particular project? I mean, doesn't that say what it says?
Yes, but if there's work that's outside the original scope, as is the case here, the fact that there's no change order for the additional work, it's not really a change, and that gets me to one of my other points. is that there was nowhere in the contract are the Petco tenant improvement plans, or for the Petco tenant improvement work.
But Petco was done in that same plaza, right?
I'm sorry,
It's unambiguously part of the project.
it is unambiguously part of the project, but the Petco tenant improvement work is not part of it. All the parties understood that there was going to be a Petco there. And the prototype plans, it's undisputed that everybody had the prototype plans at the time of the execution of the contract. But the Petco prototype plans are not site-specific. And the contract, while the parties may have understood that a Petco was going to be there, there's no internal detail. Any of the plans or specifications that are attached to the contract and made part of the contract that specify what exactly needs to go in there for the Petco tenant improvement. I mean, Brexton understood that there was going to be at least a shell, a white box or vanilla box. But that just had very bare bones, minimal elements, such as strip lighting. There was no plumbing. There was no internal rooms. There was no office space. There were dog cages that needed plumbing. None of that stuff was in any of the contract documents. So,
Isn't that typical though, on a construction plan?
well,
That there's not everything is thought out?
but the parties, Your Honor, the parties in this case all understood that the Petco tenant improvement work was to be negotiated between the parties under a separate contract. And because the Petco tenant improvement plans, not the shell, not the white box, but the actual tenant improvements, the parties all understood that that was going to be under a separate contract. And in fact, the provision that Counsel for Elyria mentioned about the architectural drawings, saying that the Petco tenant improvement work would be negotiated or dealt with under a separate contract, even if the court doesn't accept the argument that that's binding and that it mentions the Petco tenant improvement work, even if the court doesn't accept that, it is evidence of the fact that the parties understood that the Petco tenant improvement work was a completely different scope of work than what was in the bid documents and what was actually agreed between the parties.
Do you think that whether the parties understood that or not is an issue of material fact here?
No, Your Honor, we do not believe it's an issue of material fact, because if you look at the four corners of the contract, there are certain plans and specifications that are included within the scope of work, upon which Brexton reviewed and submitted their bid. The Petco tenant improvement plans were not in the attachments and the exhibits to the contract. They're not within the four corners of the agreement. And when you look at the exhibits that were actually attached and incorporated by reference, the plan specifications that were attached and incorporated by reference into the contract, you'll see that the work that Brexton bid and actually contracted for with the initial GMP agreement was the shell, the outer part of the building. There were no tenant improvement.
I have another question. Wasn't there a writing after the contract where your client signed something certifying that they received their full money pursuant to that contract?
Yes, Your Honor, and our position is that, yes, Brexton did sign that, and that's undisputed.
And that was the contract that had something that was a Petco in it.
I'm not sure I understand.
The original plans involved the plaza and the Petco.
Yes, but it did not include the Petco tenant improvement work. It included the Petco, again, everybody understood that there was going to be a Petco there, but the only plans that Brexton had at the time of the execution of the contract were for the shell of the building, not the tenant improvement. So when Brexton signed that final pay application that does have that language that this is full and final payment, Brexton was only signing that with the understanding that that's final payment only for the scope of work included in the original contract, not for the Petco tenant improvement plans.
And with regard to the Petco tenant improvement plans, was there ever a written contract with regard to that, or was it disputed orally what the terms of that project were?
There was no written contract ultimately for the Petco tenant improvement plans.
Between it. And so there's, even with regard to the terms of, your client is saying that there were terms reached about that were separate.
No, Your Honor,
Then where'd you come up with the $495,000?
well, so because the parties never executed a contract for the Petco tenant improvement, a separate contract for the Petco tenant improvement plans as they understood, because that work is outside the scope of the original agreement, then unjust enrichment and equitable relief is available. And the court granted summary judgment in Brexton's favor on the unjust enrichment, and then there was a trial on the damages, and Brexton presented evidence with respect to the damages for unjust enrichment. And that brings up another point. Again, Brexton relied heavily on Foster Wheeler and Dugan and Myers, but Foster Wheeler was decided 30 years ago. And Dugan and Myers, I think, in 2007. And since Foster Wheeler was originally decided, Ohio courts have been kind of chipping away at the harsh realities of that opinion. For example, and this is cited in our brief, Tessar versus Republic Steel. In that case, that was decided by this court, the 9th District, in 2018. In that case, a contractor brought an action against an owner for both breach of contract and unjust enrichment. That case went to trial, and the court, there were questions to the jury on breach of contract, what was in the original scope, and did the owner breach the contract? But for the additional work, that was not included in the original contract, that was performed by the contractor, the court allowed the question to go to the jury. If you find that the additional work was not part of the original contract, unjust enrichment is available. And again, that case was decided in 2018, so we're not disputing what Foster Wheeler and Dugan and Myers say, but courts subsequently have decided that unjust enrichment is available.
Right, but wouldn't that be a question for the jury then in this case, if we found that there was issue of material fact?
Well, Your Honor, the only question in that scenario, if Brexton were to be claiming breach of contract, well, Brexton did claim breach of contract and unjust enrichment. The court dismissed breach of contract claims for all parties and allowed the unjust enrichment claim to go to the jury because the trial court decided correctly that the Petco tenant improvement work was not part of the original scope of the contract, and Brexton did not, and for that reason, Brexton did not need to comply with the change order requirements, and unjust enrichment is available. So, and we didn't, Brexton did not file did not submit an assignment of error or appeal what the trial court did with respect to the breach of contract claim. We believe that the trial court correctly decided that the Petco tenant improvement plans was never part of the contract, and for that reason, unjust enrichment is available. The court determined, based on the record evidence, that for Elyria was unjustly enriched, and the issue of damages went to the jury. So, in short, we ask that the court affirm the trial court decision, granting summary judgment in favor of Brexton on the unjust enrichment claim and the award of damages. And also mention with the remaining time I have, there were two, when this court sent the case back to the trial court the first time, there were two primary issues that the trial court needed to resolve, or at least two primary issues that the trial court perceived they needed to resolve. Number one was this issue with section 2.3.4 of the contract, which state, and this is what defines contract documents. So contract documents, all the plans and specifications that Brexton bid on and priced out for this work under the original contract, defines the contract documents, and frankly, in for Elyria's brief, they kind of truncate this provision. I think it's important for the court to understand the full context, which the trial court did. And that provision says the contract documents consist of this agreement, the existing contract documents listed in section 15.1, drawings, specifications, addenda issued and acknowledged prior to execution of the agreement, information furnished by the owner pursuant to subsection 3.15.4, and modifications issued in accordance with this agreement. For Elyria asked the court to take a little snippet of that section 2.3.4, which is addenda issued and acknowledged prior to the execution of the agreement. But when you look at the full context of that provision, it's clear that the phrase addenda that issued and acknowledged prior to execution of this agreement only modifies the word addenda. And the trial court got this right. The trial court basically held that for Elyria would be asking the court to basically rewrite the party's contract and insert the word "and" in between specifications and addenda.
And counsel, I'm going to have to ask you to wrap up. You're going over time.
Thank you, Your Honor.
Thank you.
I have nothing further, and again, we respectfully request that the court affirm the trial court decision and granting Brexton's push for summary judgment on unjust enrichment. Thank you.
Thank you, counsel. Counsel, you'll have about 4.5 minutes.
I'm just gonna focus on the issue of the four corners of the contract. The trial court and Brexton posits that looking at the four corners of the contract, the Petco tenant improvement work was not included. That can't be farther from the case if, again, you read all of the terms of the contract. The contract includes a date for the completion of the Petco. That's part of the contract. The contract includes multiple provisions which acknowledge and suggest that completed or final plans may be submitted afterwards. 3.3.3, 3.4.5, all of those acknowledge and provide an understanding that there may be work for which additional or greater or more plans come out after the fact. And that is why these contracts include change order provisions. It becomes incumbent upon the contractor who receives those final plans, which, by the way, Brexton asked for and received. During the course of the project, they said, hey, do you guys have the final plans? Can we get those? It was at that point that they needed to look at those plans and determine whether or not there was some scope of work, as he was describing, some additional plumbing, whatever the case may be, racks, registers, I don't know, whatever it is. If they weren't able to ascertain that from the prototype plans that There is no question that they had before. And they want to limit, again, that section he just was referring to at the end, to addenda issued and acknowledged before contracting. But there's no reason to limit it to that. There were plainly drawings and specifications that were issued and acknowledged prior to contracting that included the Petco prototype plans for the tenant improvements. Everybody knew, and I think he just acknowledged, everybody knew there was going to be tenant improvements in this Petco. If Brexton believed that their GMP didn't have enough information to properly bid that, then they must follow the change order procedure. They didn't. And under the authority of Foster Wheeler and Dugan Myers, however old Foster Wheeler is, I would submit that that means it is very well settled and established law that has not been overturned by the Supreme Court. The fact that they did not submit that change order bars their relief. And the fact that the change order provision exists means it is within the scope of that contract, and they may not recover on any claim for unjust enrichment. Equity has no place where the parties have a written contract. That is well settled law. The trial court here wanted to get to a result. It wanted the result to be for Brexton to get paid for that work. It worked backwards to do that. Tried to figure out how it could find something in those, in the contract to suggest that, okay, it's not in the scope of the contract, you know, they messed up, but they probably should get paid because they did the work. That is not in accordance with the law. There can be no equitable claim for unjust enrichment because the Petco tenant improvement work was unquestionably within the scope of that contract. And I will give, perhaps that is not so clear. Maybe there are some things that suggest it is, and maybe there are some things that suggest it's not. But that means it's a fact question, looking at the extrinsic evidence. And when we look at that extrinsic evidence, all of that leads to the conclusion that it was in fact part of that.
But is the judge supposed to weigh that extrinsic evidence in summary judgment, or is he supposed to decide whether there's an issue of material fact? And if there is an issue of material fact, that would be going to a jury.
Yes, if there is an issue of material fact. In other words, is there some extrinsic evidence to suggest
Contrary extrinsic.
Correct. My position is that all of the extrinsic evidence establishes that it is within the scope of the contract. So, yes, the trial court should have ruled in favor of Brexton on its breach of contract claim in that regard.
And counsel, I'm going to have to ask you to wrap up.
Okay, and just to conclude, again, we ask that the court reverse the judgment of the trial court granting summary judgment in favor of Brexton on its unjust enrichment claim and against Elyria on its breach of contract, slander of title, and fraud claims. Thank you.
The court thanks both parties for the presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you.
Thank you.